Uh, Good morning, everyone. Thanks for joining us this morning for the latest episode of DLA Piper Planning and Infrastructure Team's outline session. For those that don't know me, I'm Sophie Stewart. I'm a partner in the team, and I am joined this morning by a very knowledgeable and illustrious panel of colleagues. I have with me Tobias Paul, an associate based in our Birmingham team, Ross Corser, a senior associate based in Leeds. And for the topic we're talking about this morning, has just returned from a very successful time spent with National Highways. And Michael Grieg, a legal director in our Edinburgh office. And I am delighted to say the author recently published of the guide to roads law in Scotland, titled Roads and Development in Scotland, a practical guide. It is now the Bible for all things highways north of the border. So thanks for them to joining me this morning. Thanks to you all
Well, not
for diving in.
highways, technically, Sophie.
Roads. Sorry,
Different,
yes.
different. Just to be difficult.
Significant difference. So this morning we are going to talk about highways and roads, depending where you are based geographically. We're going to have a quick canter through the various kind of aspects of the journey of a highway, from how they come into being, works that are required to be done, how we can stop them up, and finishing with some practical considerations, hints and tips for highways and roads in a development context. As ever, if you do have any questions, please pop them in the Q&A function, and hopefully we'll have some time at the end to get to them. So starting this morning, we were having a chat before we went live, and I think we're all agreed in terms of basic legal principles and statutory provisions. There's quite a lot of similarities between England and Wales and Scotland. But procedurally, we've discovered actually there's quite a lot of divergence and quite a lot of difference. So hopefully that's something that will come out for you all today. But starting at the very beginning, the highways network incredibly well established. It's fair to say, certainly all over the country, you find examples going back hundreds, if not thousands of years, of turnpike roads, Roman roads, and even predating the Romans, tracks and existing rights of way. So we kind of take them for granted a little bit. But if we start at the beginning, how exactly do highways or roads actually come into being? So Tobias, I think you've got some views certainly on common law principles.
Yes, I suppose I'll start with what all the law lecturers and textbooks start with, which is common law prescription. So if you can prove that it's been used as a highway since 1189, when King Henry II died, then congratulations. No one ever bothers with that anymore. So I'll just sort of move on to sort of on a practical level, the mechanisms which sort of are most frequently encountered. The first is actually moving away from the common law. One which sort of will frequently come up simply because it's written into the Highways Act 1980 is a section 31 presumed dedication. And the word dedication is important because the standard test for creating a highway is that there has to be dedication by someone with the power to make it a highway, generally the freeholder in England. And there must then be acceptance by the public. And that, on a practical level, can just mean that they use it. Section 31 intervenes whereby the landowner hasn't necessarily come out and said, I am dedicating this as a highway. But nevertheless, if it is actually used by the public as of right, and I'll come back to that phrase in a moment, for a period of 20 years, then if someone pops up to say, hang on, what are you doing? Then that 20-year period will, under Section 31, be sufficient to create a presumption that the landowner intended to dedicate it and did dedicate it. And obviously, because this Section 31 process relies on people actually using the route in question, then that is normally sufficient to sort of constitute the acceptance as part of the same package. Section 31 isn't absolute. So it is possible for a landowner to prevent it coming into effect by depositing a statement with the local highway authority. And in effect, you put in a list and a map showing your property and all the various rights of way or other highways which you intend to be dedicated. And then it means that if some other route is contended for by, for example, a local ramblers group, your deposited statement will then, in fact, prevent the operation of this 20-year period in Section 31. You do have to remember to keep redepositing the statement periodically as well in order to continue to benefit from that provision. The other sort of main mechanism which comes up is back to the common law, which is that at common law, if there is evidence from which we can infer an intention to dedicate, then that can be sufficient. And there's no minimum fixed period like the 20-year period in Section 31 for that. It could be less time. Generally, it's more time because you want to try to establish that something has been in long use like that. Generally, the longer it happens without anyone objecting, then the stronger a case you have. And again, for the acceptance part of the test, use by the public as of right as a highway will be accepted as evidence that the highway has been accepted after the inferred dedication. On that front, it's important to note that the use by the public must be of the highway as a highway. So what that in effect means is that a highway is just a general right for the public to, it's normally called pass and repass along the highway. So in effect, to go up and down it. You don't necessarily have to be going to a particular destination. There are actually cases where a highway has been created because people have been going to the edge of the cliff to look at the local beauty spot, that sort of thing. But the key thing is that the activity which has to be carried on has to be that passing and repassing along the highway, traveling along it. If you're doing something else on the land, then that wouldn't in itself normally count. For example, if you're holding a local fete or something like that, that's not something which would be relevant to the highway creation test. There's one other point which I think demonstrates how, whilst highway law often comes up in the context of development, nevertheless, it does pop up elsewhere too. It was a case in the Court of Appeal a couple of years ago called Barlow against Wigan Borough Council. And the case was actually nothing to do initially with highways at all. What had happened is Mrs. Barlow had been walking through a public park and had tripped over a tree root, and she wanted compensation for her injuries on the basis that the council should have maintained the path better. And so, in effect, the argument, the preliminary issue, which went all the way up to the Court of Appeal, was whether the council was actually under any duty to maintain that path at all. I won't go into the details of sort of how you identify whether the council's liable to maintain it or not. But the key point is that there'd been quite a lot of discussion about who had originally built the path, was it built as part of the park, what powers was the council using at the time, and so on. The Court of Appeal, in effect, said that's all very interesting, but that's just needlessly complicated. And they just defaulted to the common law inferred dedication and acceptance mechanism. And so the reason I sort of flag that is that quite often, I think, people forget about it. We go right into the detail of the Section 31 20-year process, but you do still need to take a step back and say, oh, hang on a minute, has this actually been dedicated at common law anyway? And so the case is a useful reminder to always keep that in mind.
And it's an interesting point you raised there, Tobias, because when we talk about creation of highway, quite often I think a lot of people default to, well, that means it's going to be a highway that's maintainable at the public expense. But of course, that's not not always the case. You can create a highway in a number of different forms. And again, Ross, a number of mechanisms are available that determines actually the status of the highway and who's going to be responsible for it.
Yes, that's right. So there are some specific statutory powers available to local highway authorities and strategic highways companies as well, to facilitate the construction of highways and footpaths. So the important point there, Sophie, is that once constructed pursuant to a statutory process, the road or path becomes a highway of the type and class intended by the constructing authority. So, if your intention is for it to become a highway maintainable at public expense, that's what it will be if you're constructing it as a highway authority. But if you're constructing it as a developer, there's another process that needs to be completed before it becomes a highway maintainable at public expense, and that is the adoption process. But before we get into that detail, there's a difference between creation at common law and creation at statute, which I just wanted to explain, which is that a highway authority that uses statutory powers to create highway can't impose limitations on the dedication of the land beyond those which are included in the statute itself. So as a highway authority creating highway under statutory processes, you are confined to what the statute says you can do. So for example, if the highway authority has constructed a highway that's only suitable for use on foot, it will be a footpath. And similarly, if it has constructed a road that's suitable for vehicles, it can't dedicate that highway for use as a footpath only. In order to impose those sorts of limitations, for example, to pedestrianise a road used by vehicles, the highway authority would need to make a road traffic regulation order. So with that in mind, I'll just briefly touch on some of the powers that are available in statute for highway creation. So Section 24 of the Highways Act 1980 is the main and sort of general power available to local and strategic highway authorities. And this power authorises the construction of any class of vehicular road. Highway created in this way is a vehicular highway maintainable at public expense. And there are additional consultation requirements where a strategic highway authority wants to construct a road that isn't a trunk road or a special road through a local authority area. And there are additional requirements generally found in statute around the creation of trunk roads and special roads. And just for the benefit of the audience, where I'm talking about trunk and special roads, there are numerous types of roads in the highway network, all of which have slightly different definitions. Trunk roads are essentially highways forming part of the national system of routes for through traffic, highways maintainable by National Highways as the strategic highways company. Think motorways and major A roads. And special roads are highways reserved for certain classes of traffic created by either a special road scheme under Section 16 of the Highways Act or as part of a development consent order. Again, think motorways, principally because they're a classic example of a special road, as cyclists are prohibited from using motorways for obvious reasons. You wouldn't want to find yourself cycling along a motorway. So the typical way in which a road is constructed under Section 24 is either that the highway authority already owns the land or will seek to acquire the land by way of a negotiated acquisition or under compulsory purchase powers, and then subsequently constructs the road. Or more commonly, the landowner will dedicate the land, allowing the construction of the road over it. And ownership of the land in that case will typically remain with the landowner unless sold to the highway authority, but control of the surface of the land is effectively forfeited to the highway authority from the point that the land is dedicated and adopted as highway land. And where the landowner chooses to dedicate the land to the highway authority in this way, as I mentioned earlier, that there is another process that needs to happen in order for that highway land to become adopted into the highway network maintainable at public expense, and that is through a Section 38 agreement, which is typically required to document the dedication by the landowner. and the acceptance by the highway authority, the process that Tobias was alluding to earlier. And this is, as I say, the process by which a constructed highway is formally adopted as a highway maintainable at public expense. And a landowner may choose to do this for a number of reasons, but principally if it doesn't want to incur maintenance liabilities in respect of, for example, its access road. But a number of legal principles have kind of formed around this concept, and they've been fleshed out as recently as 2022 in the Supreme Court. And whilst a planning authority can require highway works to come forward as part of development or a development proposal, such as typically found in the planning conditions, which may require the prohibition of occupation until highway works have been completed, that mechanism can't be used to require a landowner to physically dedicate the land as public highway. And this principle was affirmed in the DB Symmetry case in the Supreme Court in 2022, which basically found that if land is required for highway purposes, the landowner must either dedicate of its own volition, or the council must use other powers to negotiate the land acquisition or use compulsory purchase powers. And just before moving on to other sort of powers found in statute, a Section 38 agreement is quite a common highway agreement that you will see. It follows a very industry accepted standard form. The agreement must be entered into by all parties who have the power to dedicate the land, and usually that's just the landowner. But where the landowner and the developer are separate entities and the developer is bringing forward the proposal, the developer will enter into the agreement as well. The developer will agree to construct the road to a particular standard, usually the latest version of the design manual for roads and bridges. And on completion of the work, a defined maintenance period will commence, after which the road will be adopted as highway maintainable at public expense, provided that the highway authority is satisfied that the road has been constructed to an adoptable standard. And the agreement will provide for other associated provisions, such as easements for maintenance of street furniture or drainage, inspection and certification provisions, and security in the form of commuter sums or bonds. It will also usually have step-in rights and indemnities as well.
Okay.
Go
on, Ross.
I was just going to touch on a couple of other powers which are less seen in the statute. So Section 25 of the Highways Act, for example, empowers local highway authorities to enter into an agreement for the voluntary dedication of a footpath. So Section 26 deals with the procedures for creating a public footpath, which needs to be by way of an order confirmed by the Secretary of State. In both of those cases, ownership of the land is not usually required, but compensation will be payable to the landowner for any depreciation in value of the land. There's also Section 30, which allows a voluntary dedication of land by a landowner to the parish council for the purpose of creating a highway. But a highway created under Section 30 is not maintainable at public expense, so it's very rare that you see that in practice. There are also some provisions in the New Roads and Street Works Act with respect to the creation of special roads and the management of them by concessionaires who are entitled to charge tolls. And of course, where highway development meets the thresholds in Section 22 of the Planning Act 2008, the powers in the Highways Act 1980 and NERSWA will not apply, and a development consent order will be required. And that obviously relates to highway development that's considered to be nationally significant.
And sorry, Ross, I was going to say, it's interesting you just touched on New Roads and Street Works Act and the Street Works Code for various types of special road, because of course we're talking a lot about the maintenance obligations and dedication of new roads that are being constructed, but of course the powers to transfer maintenance liability between frontages and local highway or strategic highway authority are contained in those bits of legislation. But I think it's probably fair to say incredibly complicated, give most people a headache, and probably outside of scope of our 50-minute session today. I don't know if you're going to say anything more on that.
Not in those contexts. There is some points, I think, later on in the session where we may touch on some NERSWA-related stuff, but yeah, I'm hoping to avoid it as much as possible.
I think there's one point, and as you say, Sophie, we've not got anywhere near enough time to sort of get stuck into the detail of it, but it goes back to the point about, for example, for a Section 38 adoption agreement, everyone with power to dedicate the highway, so the freeholders and the bank, I suppose, needs to sign up to it. I've worked on a couple of development sites where the developer had a long leasehold and the freehold was unregistered. No one had any idea who the freeholder was. And the company that had originally granted the lease, which we could identify because their name was on it, they'd gone into voluntary liquidation several decades before. So we didn't know, had they sold the freehold to someone else and it's still unregistered, or was it wound up as part of the company assets and now it's reverted to the Crown, or something else? The way we got around that was through the private streetworks code, and this required a lot of sort of discussion and negotiation with the highway authority, because I don't think they sort of, I think highway authorities are not normally inclined to spend money on things they don't have to, so they don't tend to go into private streets and do works in them. But the workaround we developed was actually under a Section 278 agreement under the Highways Act, where in effect we agreed that we would pay for the cost of them upgrading our streets to the right standard, and would indemnify them for the compensation. So even if you're not the freeholder, as happened in that case, that doesn't necessarily mean that there's nowhere you can go, but it's going to be a lot more complicated.
Yeah, and it's a really interesting point, Tobias, and it probably moves me quite nicely on to coming to Michael, where I've already been told off for calling roads highways. It's interesting listening to Ross and Tobias and I speak, because we use the terms fairly interchangeably, but it's very definitely a road north of the border. So I guess to you, Michael, we kind of touched at the beginning, basic legal principles, quite similar, and I'm guessing quite similar in terms of regimes for creation. But when we actually start to look at practical construction or works to the highways, the regimes differ significantly.
Yeah, they do a wee bit, yes. I mean, essentially, well, I suppose the starting point is essentially what a road is, and quite simply, a road's a way over which there's a public right of passage. And in Scotland, there's three fairly well established types of way, which is a neutral term we use to describe these things. So you've got public roads, and those are ways over which there's a public right of passage that's maintained by the Roads Authority. And then you've got private roads, and these are also ways over which there's a public right of passage, but they're maintained by somebody else who's not a Roads Authority. So essentially, two types of roads, and the differentiation is just who's liable to maintain one. And then a third type of way is a private access, which is quite simply a way over which there's no public right of passage. So it may well be an access up to a private house, potentially a group of houses, and I'll come on a little bit and talk a bit more about that. Now, in terms of how a public right of passage, which is that's the test for whether a road exists or not, in terms of how that can come to be created, the courts have confirmed there's essentially three ways for that to happen. The first one is through statute. Similar to what Ross had said, there's obviously powers under the main legislation, which is the Roads Scotland Act 1984, which is quite similar in a lot of ways to the Highways Act 1980. There's powers for roads authorities to construct roads. So that could be the Scottish ministers as trunk roads authority, establishing new trunk roads or other types of roads. Or it could be the local roads authority, local authority constructing a road, and similar to what Ross says, where they do that, that has the effect of creating a public right of passage. There's also sort of provisions in terms of creating public rights of passage over toll bridges and the like, albeit we don't actually have any toll bridges anymore in Scotland. But the main mechanism through statute that a public right of passage is going to be created is through what we call a road construction consent. This is where things diverge quite a lot, because in Scotland, we don't really have a concept of dedication as such, and we don't have agreements to create roads. It's not a contractual process. It's fundamentally just a regulatory process. So if you want to build a new road, you need a road construction consent, and it's an offence to construct a road without road construction consent, albeit there's questions as to how that offence could actually occur, but never mind. But that's the main way in which most roads are constructed in Scotland. Any new road anyway has to be through an RCC. So statute's the first method of creation. We also have creation through use, which is similar to what Tobias was talking about, but without this concept of dedication. So the courts have taken quite a long time to establish what the tests for establishing right of passage through use are, but essentially you've got to follow a more or less definite route. It's got to be shown to be use as of right as opposed to tolerance and use for 20 years. So again, similar to south of the border, but without this kind of dedication concept, and it's entirely common law. So there's no kind of statutory overlay of that. And again, it doesn't need to be between two public places. So you can have a public right of passage created, kind of like Tobias's example of going to the edge of the cliff to have a look. Though why you don't want to do that in Scotland is beyond me. And cul-de-sacs and the like. The other way that the courts have said can be technically used to create a public right of passage is through grant. This is a very undeveloped concept. But what the courts have said is that certain ways may be allowed. You can lay things out in such a way as it's obvious that you've intended to create a right of passage. As far as I'm aware, there's not actually any case law to actually set out circumstances in which that will happen. All we've had are cases which have said this isn't an example of that. So technically it's possible, albeit how it would happen, nobody really knows. And in any event, I don't know if you could, I think it would have to be something that had been established some time ago, because you'd need to, you know, if you're seeking to build a new road in such a way now, then it would require road construction consent anyway. So I think it's possibly more of a historic anachronism. It's not something that's really occurs in practice. It's more sort of theoretical concept. So those are the three main types of way and of method for creating a public right of passage. In terms of adoption, as I say, the main way in which roads are created is through road construction consent, where a road is completed through road construction consent. Then the developer can apply to the Roads Authority for that to be adopted, and if built in terms of the consent, it has to be so. The public right of passage exists whether or not it's adopted, and it's entirely up to the developer to decide whether or not they wish to do so. So there's an option there as to whether your road becomes a public road on adoption or whether you keep it as a privately maintained road. There's other ways in which a road can be adopted as well. So if you've got an existing private road which may have been constructed many, many years ago prior to the road construction consent process appearing, there's a mechanism for the frontagers of the road, i.e. those people who own the land on either side of the road, to apply for it to be adopted. There's also mechanisms for roads authorities to the other way around, really. They can serve notice on the frontagers of the road and require it to be adopted. Similarly, they can also do the other way around. So there's de-adoption provisions, and all this is statutory, subject to notification objection processes with appeal to the Sheriff Court in the event of a dispute. The one other thing that maybe just mentioned is that all of these adoption powers only apply to roads. So roads authorities don't have any power to adopt what I refer to as third category of way, private accesses. So they can adopt private roads, but they can't adopt private accesses. So that's a kind of overview of where things lie north of the border.
And it's interesting you speaking there, Michael, about the RCC regime. Presumably then there aren't permitted development rights in Scotland that exist in England for the benefit of highway authorities?
There are some permitted development rights. Certainly, well, roads authorities obviously have permitted development rights. Scottish ministers have got, well, essentially they don't need planning permission to construct a road. Local roads authorities have got a certain level of permitted development rights within the boundaries of an existing road, or up to a certain amount of money. There are permitted development rights in relation to private accesses, but not so much in relation to private road that would generally need planning permission.
Because it kind of segues us nicely, I think, onto we've looked at how roads can be constructed, and the various mechanisms that exist to transfer the maintenance liability across to highway authorities. But I suppose the next natural topic to look at is once the road exists, particularly where it's adopted, what do we need to do when typically works need to be carried out as a result of development that's been granted planning permission? So we touched on limited PDR in Scotland, and Ross obviously much wider in England and Wales. But if you'd like to,
sure, yeah. So where you've got development that is either highway led or where the highway aspects of the work are a small part of the scheme, so like a student accommodation scheme or something like that, you may and almost certainly will need planning permission for your highway works as well, and usually they're built into the scheme. You may also need to carry out an environmental assessment depending on how large the highway aspect of the works is. But in addition to planning permission and where your highway works are to an existing highway, where you are the highway authority or your works interface with another highway authority, you may need to secure license to carry out those works over and above obtaining planning permission as well. But dealing with the planning permission first and the PDR aspects of that side of things. In England, there are a number of permitted development rights which apply to works carried out to highways. They're quite broad. And in certain circumstances, planning permission is deemed granted through permitted development, and an application would not be required. But before I touch on those specific circumstances, I think it's probably important to point out the legislation in the Town and Country Planning Act 1990 actually allows highway development to take place that isn't within the parameters of Section 55 development in the first place. So works carried out on land within the boundaries of a road by a highway authority required for the maintenance or improvement of the road don't require planning permission at all. And similarly, works required to break open a street for the purposes of inspecting, repairing, or renewing utilities apparatus doesn't require planning permission at all. And it's not that permitted development rights applies to those provisions or those types of activity such that permission is deemed granted. It's simply that the work does not constitute development at all. And that gives quite a lot of flexibility, I think, to particularly highways authorities and to utilities companies. And you see that a lot through the NERSWA regime. In terms of permitted development that would apply to other operators or to highways authorities as well, you've got a number of provisions in the 2015 order. So you've got Part 2, Class B, which relates to the formation, laying out, and construction of a means of access to a highway which is not a trunk road or a classified road, where that access is required in connection with development permitted by any class in the schedule. So this provision allows a developer, where it's constructing development under permitted development, to include its access provisions as well. So quite a narrow permitted development right, I think, in terms of your actual scheme has to be brought forward through permitted development, and then you can bolt on your access effectively. But conceivable, as permitted development rights do get expanded in certain areas. But to mention as well that permitted development right, obviously, whilst would be very beneficial if you had access to it, doesn't obviate the need for a 278 agreement where you are connecting into an existing highway, and that's quite an important point to make. Planning and the highways aspects of this type of development are very separate, and just because you have planning permission doesn't mean that your works to a highway are effectively licensed. That would be a separate process, which I'll come on to. Another permitted development right that may be applicable is Part 9, Class B, which is works carried out by the Secretary of State for Transport or National Highways in connection with or incidental to the exercise of its functions, specifically under the Highways Act 1980, which is clearly a very broad permitted development right, which, whilst applying to the Secretary of State for Transport on national highways, conceivable that as a developer you may want National Highways to carry out the work if you were funding them and you had entered into that arrangement. So in such circumstances, if they were carrying out functions under the Highways Act, it wouldn't necessarily need planning permission because you'd have the benefit of this right. Part 9 Class C is another one, so that's very, very bespoke to the construction of tram tracks, telephone cables and apparatus, some street furniture required for the operation of public service vehicles, tram and bus shelters, and any other development on operational land of a tramway or road transport undertaker. It's very, I say it's now, it's broad, but only to certain types of operator, I think. Part 9 Class D is setting, maintaining and improving or altering toll facilities or parking associated with toll facilities. Again, that's very narrow. And finally, you've got Part 9 Class E, which is works within the boundaries of an unadopted street or private road required for the road's maintenance. So that one's narrow, but it depends very much on the nature of the road itself. If it's a private road, then you're probably going to have the benefit of that. So again, in those circumstances, planning permission is deemed granted, but this isn't the only requirement for your scheme, particularly where you're a developer and you're not a highway authority. You will also need to overcome some of the provisions of the Highways Act as far as licensing your works are concerned. And I think that leads us on to sort of what Tobias was mentioning earlier, which is very much the sort of 278 provisions of the Highways Act. One point which many people are sort of aware of in passing is the offence of obstructing, depositing materials or damaging or breaking open an adopted highway without lawful consent. And this is a criminal offence contained in sections 131 to 137 of the Highways Act 1980. And so where you've got planning permission for your works and you're proceeding with your scheme, if your works include works to an adopted highway, or to an adopted highway, whether that be a publicly maintainable highway or a privately maintainable highway, the works themselves could be an obstruction, and therefore your works could trigger this offence. An obstruction can be anything that prevents people passing and repassing along the highway. It doesn't need to be blocking the whole width of the highway, and it's not necessary to prove that anyone was actually physically obstructed, merely that there was an obstruction. So your works could trigger this offence. So in addition to planning permission, you will also need license to overcome the lawful consent part of this provision, and that is in the form of a 278 agreement. And the provision actually requires that the highway authority must be satisfied that the works will be of benefit to the public. They'll enter into an agreement with any person for the execution by the authority of any works which the authority are or may be authorised to execute. So the express wording actually provides that the authority will carry out the works. And as a result, I think it's fair to say really that the 278 agreement is both a licence granting lawful consent, but also a funding mechanism to pay for the works required and carried out by the authority. But really, in practice, what you see these days is that most highway authorities don't carry out the works, and have established practices basically for allowing developers to carry out the works themselves, provided that sufficient security is put in place in the form of a bond or cash deposit to allow highway authorities effectively not to be holding the can if a developer carrying out the works ends up going bust, for example. Similarly, the 278 follows a very industry standard form.
Thanks, Ross. And I think when we get on to the practical considerations at the end, there's some interesting points raised around, although some of the PDRs are quite narrow, actually, when they can be really, really useful for developers in bringing forward schemes that they exist and can cut delay. I'm thinking particularly around bus stops. If you've got a residential estate coming forward and you know you're going to be obligated to put a new bus route in, but you have no idea where the public service carrier is going to want their stops to go at the outset. You haven't got to go back later for further planning permissions once that's crystallised before you can build the shelters. So interesting. I wonder, Michael, in terms of works to existing roadways to connect in new development, what's the position in Scotland? And then perhaps if we can move on to, because I'm aware we've got a lot to talk about this morning and we're running short on time. Now we've created highways, worked on them. I guess we need to come on to how on earth we close them down, because the Triton position once a highway, always a highway.
Oh, that's right. I mean, in terms of works to roads, it's slightly different. What consents you need to do will depend on what the extent of the works and what the status of the adoption status of the road is. So, as well as needing road construction consent for construction of new roads, you also need that for if you want to extend the road. So sometimes there can be a debate about what the work is. Is what you're doing an extension of a road, or is it just works to the existing road? So road construction consent for extensions for works within the road, digging it up, forming a new access into it, that sort of thing. Generally, that would be what we call a Section 56 consent. That's not in the form of, normally, we don't have, it's a consenting process again, as opposed to an agreement, albeit what's interesting maybe is that there's a considerable variation in the form of these consents. So sometimes it can just be an exchange of emails, albeit that there's not an official mechanism for the agreements in relation to Section 56. It's quite common for some authorities to, particularly Scottish ministers, to require an agreement setting out provisions for undertaking the works, including bonds. So there's quite a lot of variation there. Similar to what Ross was saying, obviously there's, as well as the consent for works, there's lots of other legislative provisions which control obstructions within the roads. So as well as the consent to undertake the works, you might also need consent for storing materials on the roads, occupying the road, that sort of thing. And also there's a different consenting process under the New Roads and Streetworks Act if you need to install apparatus in the road. And probably worth just bearing in mind that the position can be more complicated if you need to undertake works in a private road, because in that situation you're going to need the consent of the landowner, not just the roads authority. So that's where we are in terms of works. Moving on in relation to getting rid of roads effectively, what we're talking about there may be situations where in order to accommodate the development, you might need to occupy part of the road on a more permanent basis. So that can be a situation where either you need to get rid of the road entirely because the scale of development means that road's not going to be there anymore, or sometimes it may just be you need to intrude slightly onto the road, that the footprint of your building goes onto the pavement. So legislation both north and south of the border provides for stopping up orders in order to terminate the public right of passage. I suppose one thing that I sometimes see is sometimes you need to think about, do you actually need a stopping up order for what you want to do? I suppose the question is whether the interference with the public right of passage is such that it's incompatible with a continuing public right of passage. I think sometimes I've seen situations where fairly substantial works can be allowed within the road through Section 56 consent, as opposed to actually stopping it up. Whereas sometimes the roads authority will think that it's so significant that those works are not compatible with the public right of passage. The other thing, I suppose, is that a stopping up order is permanent in nature. Sometimes you might just need to temporarily stop public right of passage, in which case what you're probably looking at is a road traffic regulation order, a temporary road traffic regulation order to stop people going up and down the road, for example, where you're undertaking demolition works. So essentially, but in terms of mechanisms, there's two principal types of stopping up powers. You've got stopping up powers that are geared towards allowing development to proceed, which is under the planning legislation. And then on the other hand, what you have are stopping up powers from where the stopping up is required really for roads purposes. So a road by itself may become unnecessary or dangerous and need to be stopped up. It's often quite common as well, where you've got major road schemes to have side road orders that reconfigure access arrangements and include stopping up provisions associated with that. Conscious of time, so I don't particularly want to kind of take up time looking at these in any detail, but that's a kind of overview of what stopping up is and how it works.
Yeah, and I think it's absolutely fair to say, and I'll ask Tobias and Ross to chip in with any thoughts, but very, very similar in England and Wales that it is in Scotland. Differing powers for stopping up depending on whether you need to get rid of a road or a highway for highways purposes or for development purposes. But I don't know if either Tobias or Ross would like to add any thoughts to that.
I think something from my perspective is it's critical to identify what type of highway you're dealing with, because that will then in some circumstances dictate what stopping up process you have to use. So for example, under the Highways Act in England, Section 116 allows the Magistrates Court, on the application of a highway authority, and the highway authority can make the application on someone else's behalf, such as a developer. But the Magistrates Court can, in the rather quaint phrasing of the section, after review, so a site inspection, make an order which stops up any highway. However, you don't have to go off to the magistrates if the highway in question is, for example, a footpath. So under Section 118 of the Act, the Highway Authority can just make that order itself. And then if there are no objections, and normally there are objections, but if there are no objections, then the Highway Authority can just confirm it directly. So that can be a lot more streamlined process. I may confess that these two sections in the Highways Act are perhaps more a matter of theory rather than any practical application, because the grounds on which the orders can be made are fairly limited to, is the highway no longer necessary? And that's actually quite a high bar to make out. The other ground under Section 116 is that, in effect, you're not actually stopping up the highway altogether. You're diverting it to a route that is, quote, nearer or more commodious, whatever that might mean. And the final practical difficulty is that these Section 116 orders, they go into the civil division of the Magistrates Court. And that's quite a niche area procedurally, and most magistrates and magistrates clerks aren't really accustomed to dealing with these orders, so you've got to hold their hand.
So you say that's potentially a practical problem, Tobias, but in my experience, and I have actually been into several magistrates' courts on applications for 116, if you go in sounding like you know what you're talking about, because they really don't understand it, they'll generally grant your order, which I find would be quite helpful. So not sure whether that's a blessing or a curse, but it's interesting. And I think probably the other point to tease out here before we move on to, and it is a practical consideration, but the actual topic of practical considerations is the timing point around highway closures. Because Tobias, I know that you're talking about Section 116 and the Highways Act, but obviously there are powers similar to those Michael spoke about in Scotland to shut for development purposes. But in that case, you have to get your order before you have interfered with the highway, because the test is slightly different insofar as it's the closure is necessitated by development to be carried out pursuant to planning permission granted. And obviously, if you've already carried out that development, you struggle to rely on the power. So there's been some interesting, I know everyone on the call today has got some various experiences in this, but interesting conversations, particularly if Section 73 applications are going to be made to change conditions on planning permissions around timings for works to ensure you don't lose the benefit of your stopping up order. And I guess before we move on, for me at the moment, one very kind of odd practical situation that's arisen is around, we have a stopping up order to permanently close a road that is currently shut pursuant to a temporary traffic regulation order that Michael touched on. Essentially, the original road has been built over. What we are doing is creating a diversion round our development so that the road will still exist, but on a slightly new route. But we now need to temporarily close the new route because construction is still ongoing, and we need to put a compound on there. And there's a question as to whether the new diverted section of route actually forms part of the original road, and therefore the temporary stopping up order can now apply to the new section without need for a further order because the original section has been stopped up. Unfortunately, we've got quite a sympathetic highways authority who have said, yes, we think that can happen. But it's an interesting question. If we got pushback in future, I'm not sure how that will play out. So now looking at these kind of weird and wonderful, quirky considerations that come up, I'm going to throw it to all three of you to the floor to wrap up. Probably your top two practical considerations for highways matters in development each, please.
I'll go first. And it's something which comes up again and again. People refer to the definitive map for public rights of way. And there are two issues with it. First of all, it's not a map, it's a map and statement, and the statement has priority. And the statement is where you go to find out potentially how wide is the highway, who's allowed to use it, where did it come from, who's liable to maintain it sometimes. I've seen that on the statement. The second issue when dealing with public rights of way on a site is that the definitive map is not definitive. There was legislation on the books to make it definitive, but that was in fact scrapped last year. And so you've got to be really careful. Obviously, yes, you refer to it because it's a good source of information, but that nothing beats actually going out on site and seeing, oh, hang on, who's that local ramblers group walking along the edge of the field to the stile? I've encountered development sites like that where there was nothing on the maps or in the records at all, and yet it was clear that there was an active public right of way slap bang through the middle of our development site.
Thanks. Who would like to go next? Ross, Michael?
I'll go next. I suppose perhaps the main one is ensuring that you actually have all the land you need for access, which is really about the issue of what's the extent of a road, and that's not always an easy question to answer. Interestingly enough, it's similar to what Tobias was just saying, that one of the first ports of call in Scotland is the list of public roads, which people is often map based, and people kind of look at and think, oh well, let's have a look at that. That'll tell me what the extent of the road is. The point is that the courts have confirmed that's not a definitive list. You can't take it as gospel. It all comes down to a question of fact and degree in the circumstances of the case. And I suppose that's really the point, that when you're looking at what the extent of a road is, what you'll often find is that the roads authorities will apply a kind of rule of thumb as to what they consider the extent of a road is, which may well be something like a metre and a half, a couple of metres from the heel of the carriageway, something like that. It's particularly difficult when you're dealing with undefined roads. It's easier when what you've got is a road that's got buildings on the other side or fences on the other side, because the general position is the extent goes from building line to building line, fence line to fence line. But when you're dealing with a more complicated situation, essentially the question is, what's the area that's dedicated to public passage? What's functionally required in order to for a road to be properly maintained? And that's really picking up, I suppose, what Tobias was saying, was that you need to have an understanding of what the physical characteristics of the road are at the location you're dealing with, to understand what the reasonable extent of the road is. So there's that. The other point, I suppose, is just generally, I think, undertaking what I would call a development audit of the types of consents that you might need, and what the timeframes are, and then building that into your development programme. That's my point.
And it's a really good point, Mike, you make about particularly the horizontal plane of the highway, because obviously we had the LBS case down in England that talked about the vertical extent being the ordinary zone of use. But in situations now where we're seeing development come forward with, for example, service strips, so all your cabling for your street lighting and things are now put into parts of verge that are essentially given over to residential gardens, or where you've got suds, for example, where you've got what looks like a highways verge, but actually could be part of a sud scheme. Where does that line lie when you've got dual functionality? And I wonder if we'll see more litigation on that point. Ross, finally, I shall come to you for your thoughts.
Thank you. Yeah, of course. I think my point is just not to overlook what is essentially the front door of your development scheme or your operational asset, which is the highway part. And I think a lot of highway interface with transactional work is typically constrained to a review of the highway search or reporting on the title aspects of the ownership of the access. But this potentially misses a really important point around highways. And I think the starting point is really to understand the status of the road that abuts your property and what that means in terms of your potential liability and how you interact with that. Is it highway maintainable at public expense? And if so, that isn't the end of the story. You need to be asking further questions like, is there a Section 38 agreement evidence in the dedication of the land? Do we have a copy of it? Ordinarily a Section 38 agreement wouldn't run with the land, but there are ways of drafting it so that it does. And that needs to be checked. Are there any sort of contingent liabilities in the form of commuted sums owed to the highway authority that we need to be aware of? And do any development proposals that we have for the land include the highway within it? Again, if it's a road maintainable privately, are you a frontager? What's the condition of the road? Does it connect to the highway maintainable at public expense? And have any notices been served under the private street works code to bring the road up to an adoptable standard? And similarly, the same questions for if it's a private road. Who has maintenance liabilities? What's the condition of the road? Who else uses the road? And again, have any notices been served under the street works code? I think we've had a question as well, which we can provide a pretty quick answer to, which is about whether a highway authority can refuse to grant Section 278 approval due to a technical departure in respect of a scheme that has planning consent. Tobias, I didn't know whether you want to comment on that.
So that I think there's a very short answer to that. There was a case in the early 1990s. It was to do with a highway stopping up proposal rather than 278, but the principle you can read across. In effect, the decision of the planning authority does not bind the highway authority when exercising highway functions, even if it's the same council. And so in a situation like the one where you've got your planning permission, but Section 278 isn't agreed, then you've got a problem.
And I suppose in order to unpick that, Tobias or anybody else, you would have to start thinking of, are the highway authority being Wednesbury unreasonable in refusing to grant a 278, or is there a legitimate highway reason? Because I can't, other than challenging on those kind of grounds and potentially going down the rabbit hole of judicial review, I can't think of any statutory or common law mechanism to reconcile the two.
Exactly. Apart from judicial review, and since the Wednesbury reasonableness test was created, I don't think anyone's ever actually successfully met it. There's no appeal.
Yeah, I guess practically what you'd need to do as part of your planning application when you know a 278 is going to be needed is actually put your GA and your technical drawings in.
Yeah.
And to the extent that it's possible, get sign off and get a 278 circulating with approval from highways, not as a consultee to planning, but as the highways department signed off on it. Yes.
There is, of course, the power gen case as well, which touches on this precise point around whether or not a highway authority's position had been considered in the determination and rejected, and whether that could frustrate the determination by acting independently. I think it's sort of, I understood the power gen case as meaning that a local highway authority had no choice but to facilitate the implementation of the planning permission by instructing that the 278 be progressed.
I think what it comes down to is the highway authority can't, in effect, use the highway process as a second bite at the cherry to attack the planning merits. And generally, you find more disputes on this where something's been granted on appeal and the council didn't actually want to approve it in the first place. But if there is actually a sort of technical reason to do with highway standards, then
yeah. I think the outcome
of
power gen would have to be the LPA would have to refuse the planning application if there was an obvious, unresolvable conflict between the highways authority and the planning authority.
And I think that's probably the distinction, isn't it, between this example and power gen, which is that in power gen, the local highway authority just didn't like the scheme, whereas in this case there is a technical reason for refusing the 278. So where there is a technical reason,
and to be honest, technical reason comes down to highway design and ought to be solvable.
Or safety, in which case it's not.
Yeah. Right. It looks like another question has popped up. However, we're already three minutes over. And I suspect this is not a quick answer as it relates to permitted development rights and EVCPs. I'm not sure who's asked it, but if they'd like to follow up with us afterwards, we'd be more than happy to have a chat, because I'm going to have to bring things to a close for today, because we are slightly over time already. So I just want to thank my panelists for joining me and everybody for dialing in. We are yet to settle on a topic for next month's outline yet. We're all hopeful we might get some clarity around biodiversity net gain and the regulations that we've been expecting to land for quite a while yet. But obviously, if they don't come, we will find another hot topic. So hopefully you can all join us again next month. But for now, thank you very much and enjoy the rest of your Tuesdays, everyone.